Well, good evening, everybody. And we are now in the offices of EBRAM, which is the Electronic Dispute Resolution Platform, just started by the HKSER government. And the person who started it is, in fact, sitting next to me. That's Teresa. And this is really just in time because everything now is being done on the internet. It would appear. So tonight we have a webinar, long awaited, on the Unpacking the National Security Law. And jointly organizing this function is the AIL and the China Development Research Foundation. I'm the chair of the academy, so I have the pleasure of moderating this webinar with my friend Mr. Lu Mai, who is in Beijing. And he is the vice chairman of the foundation. Now, this webinar is being conducted in English, but there will be simultaneous interpretation, which I believe is now operating. So anybody who wishes to have a Chinese channel, you can click on. 大家今天虽然是用英语来进行，但是呢，大家都可以看到呢。
This webinar will be conducted in English, but will provide simultaneous interpretation services.
那么如果大家想用英语的话，你就可以呢。
If you wish to choose the language, please press the button under the screen.
都是双语来进行的。So this and also, if you have any questions at the end. After the speakers have spoken, then we will be answering those questions. But meanwhile, if you have any questions, please put them in writing. And we do have, in fact, a function in your computer which allows you to put in questions in writing. So we will be seeing that. And I will try my very best to ensure that your questions get answered. Everybody knows, of course, that the Hong Kong's national security law is a national law. Now, although it is only applicable to Hong Kong through Annex 3 of the Basic Law, the National Security Law was passed by the National People's Congress on the 30th of June, and it entered Hong Kong law through Annex 3. Well, Hong Kong has been suffering without, in fact, a national security law for a very long time, although the Basic Law, of course, does, in fact, put it as a responsibility of the HKSER to enact one, but we never did. So the National People's Congress enacted it, and it became Hong Kong law through Annex 3 of the Basic Law. And the reason for that is relatively simple. That's because, of course, for the past year, Hong Kong has seen one of the most challenging times that we've had for a generation, seeing the disturbances and the destruction in the streets of Hong Kong. And when the law was about to be passed, the nearly 3 million people put their signatures on a petition for the law to be passed. And also, of course, this after the law came in, the business community has welcomed that. Now, it doesn't mean that, of course, there is universal acclaim for the law. There have been voices against it by politicians and by countries around, by Western countries around the world, although 53 countries have actually supported this law. So tonight we have really 4 people who are best placed to unpack this law for you. And we have the Secretary of Justice, who's sitting next to me, then Professor Chen, who's the leading constitutional lawyer in the PRC, then Mr. Justice Litton, who was the former Justice of the Court of Final Appeal, and then finally, Martin Rogers, who is one of the leading litigation and regulatory lawyers in Asia. So I think we'll have an exciting evening, and I think an informative evening, dealing with this subject. Before we continue, I'd like to call upon my friend, Mr. Lu Mai, just to say a few words. Lu Mai.
Thank you, Tony. I'm a vice chairman of China Development Research Foundation. We are very honored to have a chance to organize this webinar together with Asia Academy of International Law. So CDRF is a non-profit organization affiliated with Chinese government think tank. We organize a China Development Forum every year since 2000, and joined by multinational companies, the leaders from all over the world. So all those companies have a directly or indirectly relations with the Hong Kong business. So they are very interested in the development in Hong Kong. CDF organized 3 webinars to invite Chief Executive Ms. Carrie Lam, Mr. C.Y. Liang, and Mr. Paul Chan Mopo. They are all from government, but now today we really have a chance to listen from a legal sides and listen to the expert in this area. So we're very happy to have a chance to join this effort, and we're looking forward to listen these 4 distinguished speakers. Their name we are very familiar, especially Judge Henry. We read a lot of your comments, your opinions. We hope Hong Kong has been always will be a popular destination for the multinational business. So I believe with everyone's joint effort, Hong Kong will continue to flourish, and I hope you all will share with me and with those confidence. With the efforts from a different group of the society, we definitely can achieve the successful in Hong Kong to see the stabilized society, to prosper in the business, and tomorrow Hong Kong will be better. Thank you, Tony.
Thank you very much, Roland. So without further ado, I'm going to ask the first speaker now to speak. Our first speaker is the Secretary of Justice, and she is Teresa Cheng, SC. Teresa.
Thank you. Good evening, Dr. Neil, Mr. Liu, esteemed panelists, distinguished guests, ladies and gentlemen. National security is a matter of top priority for any state, a basic prerequisite and foundation for the survival and development of a state, and an important cornerstone of stability. It concerns the core interests of a state and the fundamental interests of its people, and is vital for safeguarding national sovereignty, unity, and territorial integrity. Safeguarding national security is undoubtedly within the purview of the central authorities and is never a matter within the scope of the autonomy of the Hong Kong Special Administrative Region under One Country, Two Systems. This is the basic principle of national sovereignty and reflects the common practice of states, irrespective of whether they operate as a unitary or federal state. Therefore, the Central People's Government has the greatest and ultimate responsibility for safeguarding national security for all parts of China, including the Hong Kong SAR. The 13th National People's Congress adopted a 2-step decision plus legislation approach for enacting and implementing the national security law. In its 3rd meeting on the 28th of May this year, the NPC made the decision on establishing and improving the legal system and enforcement mechanisms for the Hong Kong SAR to safeguard national security, and delegated its standing committee to formulate the national security law. In its 20th meeting on the 30th of June, the NPCSC passed the law of the People's Republic of China on safeguarding national security in the Hong Kong Special Administrative Region. Pursuant to the NPC decision and Article 18 of the Basic Law, the National Security Law was added to Annex 3 of the Basic Law, promulgated, and became applicable to the Hong Kong SAR. The enactment of the National Security Law is not only constitutional and legitimate, but also reasonable in the light of the circumstances that prevailed in Hong Kong since 2019. According to the Declaration on Principles of International Law concerning friendly relations and cooperation among states, in accordance with the Charter of the United Nations, unanimously passed by the General Assembly in 1970, the elements of sovereign equality include, inter alia, that each state enjoys the right inherent in full sovereignty, and the territorial integrity and political independence of the state are inviolable. The purpose of safeguarding national security is to protect these sovereign rights. As a matter of international law and practice, enacting and implementing national security legislation is without a doubt an inherent right of every sovereign state and falls within the internal affairs of a sovereign state and should be free from intervention by other states as enshrined in the international law principle of non-intervention. When considering the national security law, one must first note that Article 1 stipulates that it is enacted to, inter alia, ensure the resolute, full, and faithful implementation of China's policy of one country, two systems. Article 2 provides that the legal status of Hong Kong SAR, as set out in Articles 1 and 12 of the Basic Law, that is, Hong Kong SAR is an inalienable part of China, enjoys a high degree of autonomy, and comes directly under the Central People's Government, are fundamental provisions and should not be contravened when rights and freedoms are exercised. Article 5 expressly protects important rule of law principles that are recognized in both civil and common law jurisdictions, such as the presumption of innocence, protection against double jeopardy, and fair trial. Chapter 3 sets out the 4 types of offenses under the national security law, which are secession, subversion, organization and perpetration of terrorist activities, and collusion with a foreign country or with external elements to endanger national security in relation to the HKSAR. It cannot be stressed enough that the provisions clearly specify the elements of each of these offenses, including the required acts and intents, what we call the actus reus and the mens rea, the respective penalties, and the scope of application. These 4 types of offenses set out under the national security law are similar to those in the national security laws of foreign jurisdictions, such as those in the United Kingdom, Canada, United States, and Australia, etc. Perhaps of particular interest is the concern surrounding the offense of collusion. It should be noted that, like the other 3 offenses provided in the national security law, Article 29 clearly sets out the elements of the offense of collusion, including the required acts and intents. Prosecutors must prove that the necessary mental element of the offense are present, and the courts in adjudicating the specific case will consider the relevant facts and circumstances of that particular case. Under Chapter 4, the HKSAR has been entrusted with the responsibility under the national security law to exercise jurisdiction over most cases, with the criminal investigation, prosecution, trial, and execution of penalty if convicted, largely following the existing legal procedures of Hong Kong. And on this point, Article 63 of the Basic Law provides that the Department of Justice shall control criminal prosecutions free from any interference. Any prosecutorial decisions, including those made with regards to offense under the national security law, will be considered upon the evidence, the law, and on the basis of the prosecution code, and never upon any political, improper, or undue influence. Turning to the issue of extraterritorial application, Article 38 stipulates that the national security law applies to the relevant offenses committed against China from outside the region by a person who is not a permanent resident of the special administrative region. Such extraterritorial application is in line with the well-recognized international principle of protective jurisdiction. As the International Law Commission notes, the principle may be understood as referring to the jurisdiction that a state may exercise with respect to persons, property, or acts abroad which constitute a threat to the fundamental national interests of a state, such as a foreign threat to the national security of a state. This principle is recognized also by the International Court of Justice in the case of the Democratic Republic of Congo versus Belgium, and followed in several international conventions against terrorism, such as the International Convention Against the Taking of Hostages, etc. This principle is also a common feature of national security laws in many other states, such as Germany, the United States, and Singapore. Another issue is that of judicial independence. Contrary to the innuendos in unfair and inaccurate statements in some media, Hong Kong's judges are free to decide their case in accordance with law and evidence, and indeed they are bound to so do under the judicial laws. In the Hong Kong SAR, the only criteria upon which judges are appointed is their judicial and professional quality, and their appointment by the chief executive is upon the recommendation of an independent statutory commission. No political vetting is involved in the appointment process. Judicial independence is premised on the solid infrastructure that has been laid down in the basic law: the security of tenure, the immunity, the non-revolving door, and importantly, the express provision in Article 85 of the Basic Law that guarantees judicial independence free from any interference. The courts in the Hong Kong SAR have been entrusted by the central authorities to exercise jurisdiction in adjudicating most cases involving national security laws. Article 44 provides that a list of designated judges who will handle cases concerning offences endangering national security is to be formed, and the power of designation rests on the chief executive. Before making such designation, the chief executive may consult the Committee for Safeguarding National Security of the Hong Kong SAR and the Chief Justice of the Court of Final Appeal. When adjudicating cases under the national security law, judges remain independent and impartial in performing their judicial duties free from any interference. Therefore, the arrangement on the designation of judges under the national security law does not undermine the highly respected judicial independence of the Hong Kong SAR. Any criticism on the national security law's effect on judicial independence is unwarranted. Indeed, the Chief Justice of the Court of Final Appeal stated in a statement dated the 2nd of July 2020 that designated judges, like all judges, are to be appointed on the basis of their judicial and professional qualities. These are the only criteria relevant to the appointment of judges. This therefore means, for example, that judges should not be designated under the national security law on the basis of any political considerations. This reinforces the principle that in handling the determination of any legal dispute, only the law and legal principle will be considered. In the Court of First Instance case of Tong Ying Kit versus the Hong Kong SAR, the first case on the national security law, Judges Anderson Chow and Alex Lee remarked this: there is no proper or sufficient basis to contend that in relation to cases concerning offences under national security law, the chief executive or the government is in a position to, quote, to interfere in matters that are directly and immediately relevant to the adjudicative function, for example, assignment of judges sitting on the court and the court lists, end quote, and that the liberty of any member of the judiciary in Hong Kong in adjudicating individual disputes and in upholding the law and values of the Constitution is or will be interfered by the chief executive exercising her power under Article 44. It must be borne in mind that a judge is bound by the judicial oath taken by him upon his appointment, which requires him to, inter alia, discharge his judicial duties in full accordance with the law and without fear or favour. The final issue is the ultimate responsibility and role of the CPG in safeguarding national security under this law. Chapter 5 of the National Security Law provides for the establishment of the Office for safeguarding national security law of the CPG in the HKSAR. In situations where the HKSAR cannot effectively perform its obligation under the national security law and becomes a risk to national security, it is certainly right and proper for the CPG to assume jurisdiction. Under Article 55, 3 such situations are specified: where the case is complex due to the involvement of a foreign country or external elements, thus making it difficult for the Hong Kong SAR to exercise jurisdiction over the case; where serious situation occurs which the Hong Kong SAR is unable to effectively enforce the national security law; and where a major and imminent threat to national security has occurred. In the above 3 specified situations, the jurisdiction of the CPG Office on National Security would only be engaged after approval from the CPG upon a request either from the office or from the Hong Kong SAR government. Lastly, I would like to say a few words on one country, two systems. I wish to reassure you that the national security law has not changed the fact that the provisions under the basic law continues to apply to Hong Kong. Hong Kong continues to maintain its capitalist system, practice the common law, and uphold judicial independence. The high degree of autonomy enjoyed by the HKSAR under the basic law in respect of matters such as independent finances, independent taxation system, monetary and financial systems, free convertibility and flow of capital, free trade and economic policy and immigration control remain unaffected by the national security law. The HKSAR also continues to be a separate customs territory and participate in the World Trade Organization as Hong Kong, China. Furthermore, as provided under the basic law with the authorization of the CPG, Hong Kong SAR will continue to conclude free trade and investment agreements with overseas jurisdictions and participate in appropriate capacities in the work of international organizations. To conclude, there is nothing in the national security law that inhibits or affects the normal operation of commercial activities and businesses. In fact, it expressly stipulates that legitimate rights of residents in Hong Kong SAR are protected. The national security law is targeted at activities that endanger national security, and it is far-fetched and fanciful to suggest that commercial activities or the daily lives of residents in Hong Kong SAR would be adversely affected. On the contrary, the law brings about stability and predictability, an environment conducive to economic and human development much desired by all. Thank you very much.
Then we have the Chief Legal Officer of the HKSAR speaking from the point of view of the Hong Kong legal system. Now, our next speaker is Professor Chen Duanhong. Now, Professor Chen is a leading constitutional lawyer in China, and he will speak from the perspective of the Chinese constitutional system. Professor Chen.
Hi. Sorry, I don't know how to put my PPT, to share my PPT with you.
Maybe I can do it for
We
you.
will now put on the PPT on the screen.
Okay, just wait, just wait. Okay, please wait.
Good evening.
Yes.
I was asked to speak on the constitutional status of the national security law, and I understand that topic comprises 2 aspects. One is the constitutional significance, and the other is the legal status of the law. And before I give my explanations, I will deliver my conclusions. That my conclusions include 2 theses. Thesis 1 is that the constitutional significance of the national security law lies in the fact that this law has materialized the constitutional identity of Hong Kong as an integral part of China in its particular ways. And thesis 2 about the legal status. The national security law is below the Constitution and the basic law, but prevails over Hong Kong local laws. And now I will come to the first thesis on the constitutional significance. When we talk about national security law, we are talking about both things. One is the political, and the other is rule of law. The discourse of national security in constitutional law is mainly phrased in the term called emergency, or the state of war, or the state of siege, or the theoretical concept is called a state of exception. The state of exception is antithetical to rule of law. So there is a battle between two camps. On the one hand, people can understand the Constitution in the absolute sense. That means in the sense of the existence of the state. And on the other hand, some people understand the Constitution in the normative sense. That means the constitutional text and the rules of rule of law. Our discussion of the constitution of significance of the national security law is mainly about domestic security. And it is a discourse of normalcy and rule of law rather than the state of exception. As I have just said, the constitutional significance of this law lies in that it has materialized the constitutional identity of Hong Kong. What does I mean by constitutional identity? In simple words, it means the similarities between Hong Kong and the mainland China, or the similarities that is shared with the whole country in constitutional terms. And here I follow Aristotle's theory, who insists that the identity of a state does not depend on its natural characteristics, but on its constitution. In this sense, a state is a polity constituted, and means that it has a constitution. But under the doctrine of one country, two systems, some people have a misconception that the Constitution of China does not apply in Hong Kong, or is totally suspended, and that the basic law is self-contained. So against this misconception, the national security law has materialized the constitutional identity of Hong Kong in the following three ways. First, it identifies the components of the state to be safeguarded. And second, it stipulates the duty bearers and the content of duties. And third, it draws the line of foe-friend distinction, and thus imbuing Hong Kong with a legal concept of the political. And I will give a little explanation for each of these three ways. First, about the components of the state to be safeguarded. The state is composed of three components, according to Professor Barry. And these three elements are the idea of the state, which includes the idea of nation and the organizing ideologies of the specific country. And second component is the physical basis of the state, and that includes the territory, the population, and the wealth, etc. And the third component is the institutional expression of the state, and that means the state machinery and its procedures and norms. Now, let's see the four types of crimes provided by the national security law and the corresponding components to be protected. The first crime is secession. It corresponds to territory and nation. The second, subversion. It corresponds to the government machinery and the organizing ideologies. The third, terrorist activities. It relates to wealth and population. The fourth category of crimes, collusion with foreign or external power, may relate to all three elements. And on this, I have two notes. First, this national security law does not specify the criminal activities against the officials, especially those people who represent the state and Hong Kong. For example, the chief executive. And note two, why does it criminalize collusion with foreign affairs, with foreign power? And I quote a German constitutional scholar here. He said, a state is not guaranteed by a power outside itself. It is not kept in motion by a motor or referee located outside its own structure. It is not carried by a heteronomous course or guarantee, but integrates itself merely by dint of an inherent logic of values into an integrating system, gravitating toward itself. Now, in simple words, a state creates itself and motivates itself. It could not be influenced or it could not be guaranteed or kept in motion by any other outside power. That's the characteristic of a state. And second, the national security law stipulates the duty bearers and the content of duties. And the duties could be characterized into the duty of action and the duty of non-action. The duty of action, we could refer to Article 6 of the National Law Security Law. And that is a generous duty. It's a constitutional duty. The duty of non-action is a specific statutory duty. And that is not to make those criminal acts. For this category of duties, I mean the duties of non-action, the barriers also include those persons who are not permanent residents of Hong Kong. And that is stipulated in Article 38. And the third point, this law draws the line of the friend-enemy distinction. National security law is a set of norms which can be used to tell friends from enemies. The political standards of friends-foe distinction are diversified and flexible, but in criminal law, and the kernel of this law is criminal law, criminal law. In criminal law, an enemy is transformed into a criminal, and the penalties must be imposed strictly in accordance with legal procedures and standards. So in general, the constitutional significance of the national security law lies in the constitutional identity. Now we move on to the second topic, the status of the national security law in the legal hierarchy. As I have said at the start, the national security law is below the Constitution and below the basic law, but above Hong Kong local laws. About its relationship with the national constitution, I think there is no need to give more explanation. The controversy involves around the relationship with the basic law. There are two current misconceptions. The first misconception is that the national security law is higher than the basic law. And the argumentation takes two steps. First, the national security law says in Article 62 that this law shall prevail. And second, the national security law is one of Hong Kong local laws. I think it has made a terrible and silly mistake at the second step in regarding Hong Kong basic law as a local law. But this is a very serious mistake, because if the Hong Kong basic law is a local law, that means Hong Kong has constitutional power. That means it has the power to make its own constitution. Misconception two, the national security law is at the same level as, or is side by side with the basic law. And this misconception also is a result of a lack of the theory of constitutional power. Without this theory, one cannot see the nature of the basic law and its special legal status. the basic law, the Hong Kong basic law and the Macau basic law in the legal hierarchy of the Chinese legal system actually is a bit more special, it's very special among the basic laws made by the the full Congress. In the Constitution, it is provided that the full Congress could make basic laws, but the word basic laws here is a generic term. It's not a special term as the basic law of Hong Kong or the basic law on Macau. So these two basic laws actually are very special among the generic basic laws in the Constitution. So its legal status is very special. It's not the ordinary, it's quite different from the ordinary basic laws. There are two hot questions here. Does Article 14 of the National Security Law contravene the basic law? Article 14 reads, decisions made by the Committee for Safeguarding National Security shall not be subject to judicial review. Does it contravene the basic law? I say no. In the United Kingdom, judicial review is a common law remedy, which could be precluded by a statute. Article 158 of the Basic Law, in no sense, precludes the National Congress from stipulating such an ouster clause. Question 2. Is Article 60 of the National Security Law in conformity with the Basic Law? Article 60 reads, the acts of duty by the CPG's Office for Safeguarding National Security in Hong Kong and its staff in accordance with this law shall not be subject to the jurisdiction of Hong Kong. I think this article is in conformity with the Basic Law. Now, to answer this question, we should compare with the doctrine of federal immunity in the United States. And we could also approach this problem from the universal model of centralization in national security law enforcement. Why should the national security law prevail over Hong Kong laws? Article 62 says, this law shall prevail, where the local laws of Hong Kong are inconsistent with this law. There are two ways to explain this. And the first way is to use the principle of minimum, I call it minimum legal identity or minimum preemption. And the second way to explain this is the same as I have just said about the first question. It's the centralization of national security and national security management. And if we read Article 6 of the United Constitution, you will find that actually Article 62 of the National Security Law follows the same logic. Article 6 of the United Constitution says, this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary, notwithstanding. Anything in contrary, to the contrary, notwithstanding. That is the same as saying this law shall prevail, where the local laws are inconsistent with this law. So under the doctrine of one country, two systems, the principle of central preemption is kept, but it is discounted to a great degree compared with federalism. First, only the national laws included in Annex 3 are applicable in Hong Kong. And second, the national laws in Annex 3 can be further divided into two types. Those promulgated by the chief executive has full superiority. Those adopted by the legal has relative superiority. Now, if we read Article 17 of the Basic Law, and we will find that the Standing Committee actually has a right to review the laws passed by the local legislature, but it could not amend it. It could only return the law. Any law returned by the National Standing Committee shall immediately be invalidated. That means if the local laws in the area of national security is not consistent with the national security law, it could be returned by the National Standing Commission, National People's Congress, and it shall immediately be validated. Thank you.
Thank you very much, Professor Chan. Now we have a view from a leading constitutional lawyer and academic in China, who saw the unifying thoughts and philosophies of one country, two system. Next, we are going to have one of the Hong Kong's most distinguished lawyers and judges, Mr. Justice Litton, and who will speak from his experience. Henry.
Thank you, Chairman, and good evening, ladies and gentlemen. I shall begin at the beginning. At the time of the handover in 1997, Hong Kong had a set of national security laws in its statute book. It was spread over 3 ordinances, part 1 of the Crimes Ordinance, the Societies Ordinance, and the Official Secret Ordinance. These were plainly inadequate to deal with the situation when Hong Kong ceased to be a crown colony and became a special administrative region of China. Article 23 of the Basic Law required the region to govern, the region of government to enact on its own laws dealing with national security matters. Now, this should have been done as the first act of the regional government, treating it as a housekeeping matter, but it was not done. So 6 years later, the government produced a public consultation document. Technically, it was superb. It made out a most convincing case for new national security law. But it also elevated Article 23 into a major political issue. The more the government consulted, the more suspicious the public became. The then Secretary for Security was given an impossible task to sell it to the public. When in 2004 a bill was introduced in the Legislative Council, hundreds of thousands of people, the old, the young, the halt, the lame, parents with toddlers, the elderly with walking sticks, took to the streets in protest. The bill was withdrawn. Nothing was done for more than 10 years, over 2 successive terms of chief executives. The region's obligation under Article 23 to pass national security laws remained unfulfilled, smoldering away like embers ready to be fanned into flame. So fast forward to the year 2019. The scene, both domestically and globally, had radically changed. Domestically, the government was dealing with violence in the streets, the destruction of public facilities on an unprecedented scale. The declared aim of the rioters was to destroy the police force and bring the administration to its knees. Now, abroad, the world was threatened with trade war, cyber war between major powers, and the possibility of hot conflict in the South China Sea. Hong Kong's position, both domestically and externally, was threatened with heightened dangers. The general population was cowed, small businesses bankrupted, livelihoods destroyed. Now, the 3 arms of government, the executive, the legislature, and the judiciary, had become dysfunctional in dealing with the situation, and Hong Kong was unable on its own to quell the crisis at hand. So the year 2019 ended on a dismal note. Now, when COVID-19 intervened in February of this year, criminal activity continued, though on a diminished scale, but national security remained at great risk. It was in these circumstances that Beijing announced in May this year that the National People's Congress would promulgate national security laws for Hong Kong. It noted with, I think, remarkable restraint that national security risk in the Hong Kong SAR had, quotes, become a prominent problem, unquotes. Now, seeing that the regional government was incapable of dealing with the situation, failing to protect the lives and livelihood of the ordinary citizen, what was the central government to do? Well, one solution, obviously, was to declare a state of emergency under Article 18.4 of the Basic Law, issue an order to apply, quotes, national laws in the region, unquotes, bring in the armed police from across the border, and thus end, in effect, the policy of one country, 2 systems, as applied to Hong Kong. The central government chose the opposite course. It proposed to enact a new national security law for Hong Kong to be administered through local institutions. The declared aim was to, quotes, fully and effectively implement the principles of one country, 2 systems, Hong Kong people governing Hong Kong, and a high degree of autonomy for the region. The May announcement specifically mentioned that in enforcing the law through the Hong Kong courts, common law principles such as the presumption of innocence and other safeguards would apply. And this was just now re-emphasized by the Secretary for Security in her excellent speech. Now, Lord Patten, former governor of Hong Kong, even before the ink was dry, issued an immediate statement declaring this to be, quotes, a complete destruction of the joint declaration, unquotes, referring, of course, to the agreement signed in December 1984, dealing with China's resumption of sovereignty over Hong Kong in July 1997. This was echoed by statements from other Western leaders, and the global media then picked up the tune. The text of the new law was eventually published on the 1st of July. It has 66 articles. Its terminology in places lacks the precision one finds in common law statutes. It therefore leaves much room for judicial interpretation. But Chapter 1, under the heading of General Principles, reinforces the safeguards to fairness in criminal proceedings to be found in the Basic Law. Article 4 of the new law is of particular relevance, and it says, quotes, "Human rights shall be respected and protected in safeguarding national security in the Hong Kong SAR. The rights and freedoms, including freedoms of speech, the press, of publication, association, assembly, procession, demonstration, which the residents of the region enjoy under the Basic Law, and the provisions of the ICCPR, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights, as applied to Hong Kong, shall be protected in accordance with the law," unquotes. Moreover, the general principles as set out in Article 1 of the new law reinforces the principle of Hong Kong people governing Hong Kong, as the Secretary of Justice has also just now emphasized. That said, the interface between the Hong Kong authorities and mainland entities may raise problems for the Hong Kong courts later on. Now, the Office for Safeguarding National Security, an organ of the central government, established under Article 5, has a wide role to play. Now, how wide is not clear. Article 49(4) says that the mandate of the office includes, quotes, "handling cases concerning offense endangering national security," unquotes. Now, the expression handling cases in Article 49(4) is wide and amorphous. If it meant, for instance, that the office has power to prosecute offenders in the Hong Kong courts, that would seem to be contrary to the general principles set out in Article 1 of the law, and would also set up a clash with the Basic Law. For Article 63 of the Basic Law is clear, quotes, "The Department of Justice of the Hong Kong SAR shall control criminal prosecutions free from any interference," unquotes. Except in a very narrow range of cases to be dealt with later, the entire process of investigation, prosecution, trial of cases under the new law is in the hands of the Hong Kong authorities. This is encapsulated in Article 40, which says that Hong Kong shall have jurisdiction over cases concerning national security, offenses under the new law, quotes, "except under the circumstances specified in Article 55 of this law," unquotes. Now, as regards the powers of the Hong Kong police under the new law, Article 43 is troubling. It appears to confer on the Hong Kong police force a range of new powers in addition to those set out in existing statutes, such as the Police Force Ordinance. Now, how these powers will be exercised later on will tax the wisdom of the courts. This law is not concerned with crimes against the person or the property as such. A case of arson, damage to public property, attempted murder, inflicting grievous bodily harm, standing alone would not be processed under this law. It is targeted at damage to national security, which is a much wider offense. The crimes of subversion, terrorism, collusion with foreign entities, etc., are all aimed at the state. Criminal intent is involved, and this is an aspect which the Secretary of Justice, again in her speech, has just emphasized. These are very serious crimes attracting long terms of imprisonment. a prosecution is not to be lightly undertaken. To charge a person under the new law, the written consent of the Secretary for Justice is required. That's Article 41(2). The notion that a young man doing nothing more than waving a banner in the streets could be convicted under this law is absurd, whatever the banner might say. Whilst instances of arson, damage to public property, taking part in a riotous assembly, or waving a banner, standing alone, will not come under the new law, they might, of course, constitute evidence of a more serious crime, such as a conspiracy to bring destruction to Hong Kong. And this would, of course, be crime against national security. Now, Chapter 5 of the new law deals with the Office for Safeguarding National Security, a mainland organ. Within Chapter 5 is Article 55, which has aroused much hostile comment. It deals with three very narrow categories of cases where, on the initiative of the office, prosecution takes place in the mainland before court designated by the Supreme People's Court. The investigation having been initiated by the office in Hong Kong, quotes, legal documents, unquotes, issued by the mainland authorities, quotes, shall have legal force, unquotes, in Hong Kong, Article 57. This means, in effect, that Hong Kong institutions may have to enforce and give effect to orders issued by mainland courts. Now, how this will work out in practice calls for great sensitivity on the part of the Hong Kong judiciary. For this will, in effect, be the principle of one country, two systems in action. That principle is a living concept. It evolves with changing times. What the Hong Kong judiciary is called upon, or will be called upon to do, in effect, is to calibrate the system so that it comfortably accommodates Hong Kong's cultural values with national aspirations, a most delicate operation. And in this regard, what Professor Chen has just told us is highly illuminating, and I hope that Hong Kong judges will study his comments, his observations, with attention and interest, because this should shape the way in which this delicate calibration of the Hong Kong values as against national aspirations encapsulated in the principle of one country, two systems will actually work out in practice. Now, no wonder that the new law has conferred additional responsibilities on the chief executive in the shape of Article 44. Now, Article 44 has aroused much controversy. It requires the chief executive to designate a new panel of judicial officers chosen specifically to handle cases concerning offenses endangering national security. Now, critics have said that this interferes with judicial independence. The concept of judicial independence is understood. It has everything to do with the exercise of judicial power and nothing to do with the institution of the judiciary as such. The judiciary does not stand apart from the other major organs of government, as Lord Sumption, former judge of the English Supreme Court, puts it in his book, Trials by State, and I quote, "It is a vice of lawyers that they think and talk about law as if it was a self-contained subject, something to be examined like a laboratory specimen in a test tube. But law does not occupy a world of its own. It is part of a larger system of public decision-making." Now, two unquotes. to reshape the function of the judiciary to better accommodate it to the larger system of public decision-making is an act of government. It has nothing to do with judicial independence. In summary, what can be said with confidence is this: the declared aim of the new law is to strengthen the application of one country, two systems in Hong Kong. This leaves the possibility that the policy will endure long after 2047, with the common law as the governing system for Hong Kong during the lifetime of the young people of today and beyond. For this to eventuate, the common law must be seen to deal effectively with problems as events evolved, particularly in the interface between the Hong Kong system and that of the mainland, with the Hong Kong courts bearing firmly in mind that the ultimate power of interpreting the new law rests with the Standing Committee of the National People's Congress, Article 65. And again, I welcome and applaud Professor Chen's illuminating explanation of the hierarchical structure of the legal system, starting with the Constitution of the People's Republic of China. Now, in the year 2049, China will be celebrating the centenary of the founding of the PRC. In all probabilities, planners in Beijing will already be pondering that major event. How will they see the role of Hong Kong at that time? As a vibrant region with an international outlook, well geared to act as a global trade and financial center, or as a nondescript, medium-sized city on the southern shores of China? Now, those seem to me to be the stakes in issue today. Thank you.
Thank you very much, Henry. I think a lot of sobering thoughts have been put forward to all of us. I think the most important of which is how our judiciary could actually calibrate, exact our jurisprudence in the one country, two systems that we have to do. Now, finally, we have our final speaker tonight, Martin Rogers, who will speak to us on the comparison of Hong Kong national security law with the laws of the United Kingdom and the United States. Martin.
Thank you very much, Tony. And let me say immediately, it's a great pleasure to be invited to participate in this discussion. And let me also say, I noted there's a certain amount of commending of other speakers. I'm going to commend the Secretary for Justice. I do think in particular it's commendable that she and the Hong Kong government is willing, more than willing, sees the importance of being open to discussion and participating in discussion. This is, on any basis, a law which has attracted some controversy, rightly or wrongly, and it's commendable that the Secretary for Justice is willing to engage in discussions with this, and long will, I am sure, that continue. So I'm a lawyer in private practice. I advise clients. I advise business. That includes banks and big companies. And as the Secretary for Justice said, Hong Kong is built on business, and Hong Kong business, and I'm talking here both about local businesses, but also international businesses that have made part of their home here in Hong Kong, want to see business going on as usual. So what I want those businesses, particularly the international ones, also have looked at this law and have asked themselves, well, what does this mean? And they have asked that question by reference, in some cases, to their home jurisdictions, to the US and the UK, perhaps in particular. So from my perspective, I thought I could add to this discussion in two ways. First, to give a very, very high-level comparative analysis of the aspects of this national security law with the law in the US and the UK. I am myself an English and Hong Kong qualified lawyer. I am a partner in a US law firm, so I think I'm reasonably well equipped to give something of a comparative analysis. But secondly, and I think just as importantly, I would like to identify in the short history that the national security law has so far had here in Hong Kong, the practical questions that have predominantly come up for business in Hong Kong. And let me make, before I have a slide deck, which I will walk through in the next 10 minutes or so, just a short number of slides. I should also say that I hope the foundation will make available to participants two memos that we have produced on setting out in more detail than I could possibly cover in the next short minutes, the comparative analysis with each of the US and the UK. So please, I hope that those will become available to you. Please study them and please ask questions. So some further preliminary remarks. Firstly, all errors in the material you get are my responsibility, and I'm sure there will be errors. Secondly, the views that I'm going to express are my views alone. They're not those of my firm, and they're certainly not the views of our individual clients that we as a firm may advise from time to time. Lastly, I'm not a constitutional lawyer in any meaningful sense. I'm a day-to-day practicing lawyer who understands a little bit about regulation and about public law, local public law. You've had some great insights from leading constitutional lawyers. I'm not going to attempt to cover the constitutional ground. I'm going to keep this much more practical. With that, let's move on, if we may, to the next slide. If I can make this technology work. Apologies, I'm struggling here with this. These are the key questions which I thought people would find useful to see, which business have asked about this law. I'm not going to read out the entire list of the questions. You can see them there, but I will highlight just a few of them. There has been, business has been interested to compare the law, the new offences in particular, also how things are going to work in terms of investigation procedure, to the position in the UK and the US. Secondly, I would highlight this question. Do organisations have an active obligation to monitor staff, clients and counterparties for potential breaches of the new law? That in practice, it may not be a significant constitutional issue, but in practice that is something that businesses are worried about. Can corporates be liable? Can corporates be vicariously liable for offences committed by their representatives? When may directors of corporates be liable? And a question which I think everybody has touched on one way or the other is proof of mens rea required? And there the pretty resounding answer is yes. Questions have been asked about legal professional privilege and privilege against self-incrimination under the law. And perhaps most relevantly for the financial services industry, which is in many ways core to the continued success of Hong Kong. Article 29, foreign collusion. How, if at all, is that going to impact on their operations? And Article 29 can really be broken down into two parts. There is the part of Article 29 which criminalizes the unlawful provision of state secrets to foreign parties. And then secondly, and really here I'm zooming in on Article 29, subparagraph 4, a provision which perhaps is not, on one view, as clear as business might like it, which relates to the imposition of sanctions or blockades or other hostile activities against the Hong Kong SAR or the People's Republic of China. And a related question, which is a new question really for people in Hong Kong, businesses in Hong Kong, what is a state secret? It seems quite clear that Article 29 has the effect as a national law of importing into Hong Kong, really for the first time, the application of the state secrets law in mainland China. I'd like to pause here and say that there has been a very strong trajectory, positive trajectory on the part of business in Hong Kong of being anxious about these questions, particularly on the 1st of July, when the new law came into force and was published, really without much prior notification of the details. That anxiety has dissipated very considerably. As far as I'm concerned, pretty much all of these questions have already received, as a practical matter, helpful, positive answers. Also to be commended in this respect are the Financial Services and Treasury Bureau, and under them the regulators in the financial services industry in Hong Kong, who on two particular dates, I believe it was the 19th of July, and then again on the 8th of August, put out helpful guidance notes to clarify two things. Really, there were two messages. Firstly, in the first set of messages, that really for financial markets, it should be business as usual, notwithstanding the national security law. And secondly, on the 8th of October, a statement in particular made by the Hong Kong Monetary Authority that whilst as a matter of Hong Kong law, compliance with foreign sanctions was restricted under the Hong Kong law to United Nations sanctions, it would be a matter of, and if I can remember the exact wording, it would be a matter of balancing legal, business and commercial risks for financial institutions in Hong Kong when it came to compliance with foreign sanctions. And you know, let's be blunt, let's talk obviously most directly about the sanctions that the US government has issued, including, for example, under Executive Order 13936. So I'm not going to address all of these questions, but I did want to touch on, in particular, as Tony said, some of the comparative issues. This slide, I hope, is a helpful way to look at the four new institutions that come into operation under the national security law in Hong Kong. I'm not really going to talk about the Office for Safeguarding National Security, but in terms of the other three institutions are the new National Security Committee of the Hong Kong government, chaired by the Chief Executive, with other members who one would expect to see, including a National Security Advisor designated by the Central People's Government, and then specialist departments of the police force and the Department of Justice. The point I would like to make, which we have made to clients, is that if you want to see a very, very similar structure to this setup, look at the United Kingdom. I do not know, I'm not privy to whether this was deliberate or not, but the structure is in my view, remarkably similar to the operational structure that you will see in the United Kingdom. Possibly the only, well, there are two differences. One is the position of the Office for Safeguarding National Security of the Central People's Government. You've heard views, insightful views, as to why constitutionally that might be regarded as wholly appropriate for Hong Kong, whereas obviously, so far as the US and the UK are concerned, you have a different political constitutional setup, so it may not be surprising at all that there's a difference there. In the second difference, so far as the UK is concerned, is, you know, for what it's worth, there is something called the Investigatory Powers Tribunal under the Regulation of Investigatory Powers Act 2000, section 55. that tribunal has the duty to regulate and deal with complaints about the way intelligence gathering, surveillance, investigations are carried out under the UK's national security law regime. We do not have a new body, but it's fair to say that if one looks at the police review procedure, if I can call it that in general terms, the role of the ombudsman, other manners in which the Hong Kong government's activities as a matter of administrative law are reviewed, one could well take the view that the establishment of a new tribunal was not necessary. We will just have to see in practice how things operate. Turning over to the next slide, a concern on the part of business was how often would cases be investigated and then prosecuted under Article 55 as special cases rather than locally in a manner which is largely going to be familiar to people who deal with investigations by the police and prosecutions by the Department of Justice. I think, as already been said, the law provides, and in practice so far, one has seen an approach which would mean that if there are any such investigations, special investigations under Article 55, they're going to happen in wholly exceptional circumstances. But I won't say too much about the designation of trial judges for national security law offences by the Chief Executive, other than to sort of merely endorse and repeat what has already been said about the essentially, it's very difficult to see why the process should call into question the appropriate judicial independence that we see in the Hong Kong judiciary. I do want to come on to one point about perception, but I'll deal with that in a minute or two. I've set out on this slide the points I made about mens rea. The main point here is that it is pretty clear already that mens rea is a requirement, even though one doesn't see express definitions of mens rea in the legislation. Yes, there is potential corporate liability. The offences don't just apply to individuals, but can apply to corporates. But frankly, that is not at all unusual. That is a common feature in existing Hong Kong law. Directors do not have some sort of special liability arising necessarily out of corporate liability. Of course, a director of a corporation could be liable for an offence, but the offence would have to be proved in the usual way against them. In terms of a comparison with the four substantive new offences, secession, subversion, terrorist activities, and foreign collusion, I would commend you to read the memos that will be made available dealing with the US and the UK, respectively. I would note that so far as subversion, terrorist activities, and indeed foreign collusion, you will see analogues of those both in the US and the UK. The US in particular has a significant series of provisions in Title 18 of the US Code providing for criminal offences of foreign collusion. The difference, if you like, is the absence of criminalisation in any meaningful way of succession in either the US or the UK. It is no part of my these comments. No, there is no intention to make any political statement in this respect. But I would just note that when it comes to the question of whether a country deems it necessary or appropriate to pass a law relating to succession, that is a constitutional matter to be determined by each individual country around the world, and there are obvious constitutional differences between the US, the UK, and the People's Republic of China and the one country, two system fundamental basis for the operation and legal framework for Hong Kong. In terms of procedure, investigations, and focusing in on what will be the vast majority of cases in practice, in my view, the non-Article 55 cases which are handled by the police. My observation would be that, and we're seeing this already, insofar as investigations are ongoing, is that the procedure adopted by the police in terms of search warrants, arrest warrants, will be conventional. That it should not be anything very unexpected or unusual. Some commentary in the international media about concern that from now on the Hong Kong police will be, searching premises without warrants. No. Exceptionally, the law provides that that will happen. But frankly, my understanding is that that was always the case in Hong Kong. We're not talking about something new. We do have a new element, which is the ability to require social media platforms to remove information subject to criminal due process. I note that that is there. Certainly, so far, business in practice has not been particularly impacted by that. I would, insofar as prosecutions are concerned, I'm not going to say too much about the question of designation of judges, only to note one practical matter. I think in Article 44, there is a provision which says that judges who have made any statement or behaved in any manner endangering national security cannot be designated. Now, I would say that there is nothing offensive or of concern objectively about that. I do want to point out as a practical matter that that has resulted in the following question being asked by international clients who are not familiar with the incredible strength of the judiciary and the incredible strength of the rule of law in Hong Kong. We have had in practice international clients ask this question: will this impede a judge in Hong Kong from deciding in a civil commercial case? Will it impede them from deciding against a Chinese state-owned enterprise in a commercial dispute? The answer, in my experience, having been a litigation lawyer in Hong Kong for 30 years, is absolutely not. But there is a perception issue. And my point here is that we all need to work extremely hard to make sure that that misperception is not continued and is dissipated. That is my point. I'm not seeking in any way to criticize that provision of law, just pointing out that in practice, it has, at least in the short term, generated a perception of risk. Another significant point in practice relates to whistleblowing. Clients have asked, do we need to actively monitor our staff, our customers, the counterparties we deal with, to see whether they're breaching the law? The answer is no. You have to be careful at the point where you realize that people may be breaching the law, insofar, and you have to be mindful of the fact that there are offences for assisting and facilitating in breaches of the law. So at that point, you have to be mindful and careful and take appropriate steps to make sure that you are not committing some form of offence of assistance or facilitation. One interesting point, which is, has meant that business has had to sort of change their practice in a little bit, is that there is an obligation where you know or suspect that any property is offence-related property under the national security law to make disclosures to the police. The issue is simply this: when one comes to look at the definition of offence-related property, it has two limbs. Limb B is what you would expect to see, any property that it is intended to be used or was used to finance or otherwise assist the commission of an offence. However, limb A, on the face of it, is much broader. It says it refers to the property of a person, which on the face of it relates, covers any property. So it means, let me put a hypothetical example out there. Assume you are a company, assume you read in the local press that one of your employees has been arrested for an offence under the national security law. Two questions then arise for you to consider. Does that put you in the position where you know or suspect that that person has committed an offence and that property of theirs which you know about is property which you will need to report to the police? That is the question that's come up in practice, and that I think in practice people are finding ways to address this and answer this. I just want to note, as a practical matter, the interesting point that the breadth of the definition of offence-related property means that the disclosure is broader than one might perhaps first think of when you look at the phrase offence-related property. It seems to cover all of the person's property. Legal professional privilege, privilege against self-incrimination. The operating principles and guidelines go out of their way, if I may say so, to safeguard and reinforce the existing law and practice in relation to legal professional privilege. No change there. In respect of a privilege against self-incrimination, the obligation to answer questions, even though the answers might tend to incriminate you with a criminal offence. Yes, there is a requirement to answer questions in such circumstances. However, the point I would like to make sure that everybody takes a very balanced approach to this is that this is not new to Hong Kong. If you look at the Securities and Futures Ordinance, if you look at Section 378, you already have effectively the same provision, and there are checks and balances built into the implementation rules for Article 43 dealing with this in the same way that there are checks and balances under Section 378. They're rather more detailed for Section 378, but nevertheless those checks and balances are there. I want to finish briefly because I do want us to get to question time by touching on really the substantive new offence which financial institutions and businesses have been somewhat concerned about how to deal with. And I really wanted to illustrate the concerns by reference to three hypothetical situations which I outlined on the right-hand side of the slide. Imagine a US company which has a business in Hong Kong, responding to a US subpoena, requiring production of information and documents held by a subsidiary in Hong Kong, which relate to its interaction with a mainland Chinese party. Is it going to get into trouble under Article 29 because the compliance with that subpoena might amount to might be said to amount to the unlawful provision of state secrets for the benefit of a foreign party? The practical point I want to make here is that in practice, it ought to be clear to a party in Hong Kong, a private business in Hong Kong, it ought to be clear from the outset whether they hold information which amounts to a state secret or not. If one analyzes carefully the mainland Chinese law on state secrets, which is now imported into Hong Kong, it would be rarely, if ever, the case, if there is full compliance by the custodians of that information in the mainland, it would rarely be, if ever, be the case that a local business in Hong Kong would unknowingly receive a state secret. It ought to be clear. If it is clear, then yes, it may well be that Article 29 is invoked. But if as far as you're concerned, you haven't been told hasn't been flagged up that you have a state secret in Article 29 should not be invoked. So in practice, I would hope that this will not be an issue. Having said that, one has the prospect that regulators in foreign countries may start requiring confirmations, for example, in the form of a legal opinion, that the Hong Kong national security law will not act as a blocking statute in the provision of information to that foreign regulator by a Hong Kong party which is looking for some form of registration or license from that regulator in the foreign company. And this is not such a hypothetical question. In fact, one is starting to see a little bit of this from certain countries overseas. Again, I think so far in practice, what I have seen is a satisfactory resolution of that question. But I want to flag that as an issue that may be an ongoing, may become an impediment to Hong Kong-based businesses in terms of getting licenses and registrations in foreign countries. So far as the last question is, what if I am a Hong Kong branch of a US bank or a European bank, and I have to comply on the face of it with a foreign government sanction against, for example, theoretically, a Hong Kong government or a PRC government official? Is that going to get me in trouble under Article 29, subparagraph 4? Am I going to be regarded as a financial institution as imposing a sanction or blockade? If we look at the next slide, and I will finish in a moment, this has been, I wanted to highlight the fact that this has been the subject of an interesting blog piece published by Professors Albert Cheng and Simon Young of Hong Kong University on 31st July. They clearly came out with a very clear opinion. They said no, private financial institutions are not capable of falling into the paragraph in question. They're not capable of imposing sanctions or a blockade for the purpose of subparagraph 4. That should be restricted in its application to only state actors. You then had the Hong Kong Monetary Authority circular, which I alluded to, which came out the day after the imposition of US sanctions. That did not refer to Article 29.4. It only talked about balancing legal, business, and commercial risk and treating customers fairly. Where does one come out on this? Ultimately, it's going to be a question of interpretation of the law in a fact-sensitive case. But I can tell you that I would certainly hope, and it's certainly my view, that the prosecution authorities will take a very sensitive view and approach to the question of any prosecution of a financial institution. In particular, if one takes the view that there is a reasonable basis for what was said by the Hong Kong University scholars, you are then potentially in a position where there are two conflicting views as to the scope of Article 29, subparagraph 4. And we have in Hong Kong a principle against doubtful penalisation when it comes to the interpretation of a criminal statute. If there are two reasonably held conflicting views, courts generally will take the narrow view. That's all I'm going to say. I'm just a lawyer in private practice. It's not for me to express a concluded view on this question.
I can fully understand why you're asking these questions, because these questions surely will be put by your clients.
Yeah.
I mean, I lead a lot of financial institutions because I chair the risk committee by CBC. So these are one of the questions that we ask ourselves. But I think the financial community and the business community can actually be comforted by what Teresa has said, that we of course live under the common law systems. And in this system, in fact, many of the tenets of the common law, particularly when a crime is put before the courts require, in fact, intent. And the proof of intent is never easy. And in fact, in terms of commercial activity, I think any court will be very slow to impute an intent, where in fact there is a commercial justification behind that act. I see that there are a number of questions, but before I go to the questions, because Martin referred to the implementation rules. In fact, we didn't talk a lot about that. Henry referred to the powers of the police, of course, which comes through Section 43, Article 43 of the National Security Law. I noticed, in fact, that these implementation rules came out quite quickly. In fact, I was quite surprised it came out so quickly from the Department of Justice, but obviously you must have drafted those, or your department must have drafted those, I would imagine. They tend to follow a lot of the procedures which are in fact familiar to us in terms of the exercising of these powers. And perhaps you might, Teresa, give us your thoughts as to sort of the philosophies and the principles behind drafting of those rules. Obviously, in due course, when these rules become controversial, they will go to courts.
Well, thank you very much. And may I say what an excellent program that you've put together. I really have learned a lot through the very, very excellent speeches that have been given. Now, Article 43 deals with certain powers that are given to the police force to deal with crimes that are endangering national security. Now, in relation to that, I think it's worth bearing in mind that when those schedules, as we call them, that are set out in the 7 schedules that are promulgated under Article 43, when that was done, we of course have to take into account the general principles laid down in Chapter 1 of the National Security Law, and that is the protection of human rights under Article 5, the principles of rule of law under Article 4 for human rights, under Article 5 for rule of law, and of course the actual balancing and ensuring the proper due process is being observed, and so on and so forth. So when those schedules were drafted, we certainly have those principles in mind, and but also to take into account that we are dealing with matters that are endangering or suspected of endangering national security. But it's also worthwhile to note another matter that I think touches and perhaps underpins why Article 43 is important, and that is in Article 3, subsection, or the 3rd paragraph of Article 3 of the National Security Law, which talks about the duty of everybody, the executive, electoral, and the judiciary, to prevent, suppress, and punish any activities that are endangering national security. And on that particular point, it's worth noting, for example, in the Tong Yin case, the 2nd case on bail review, the judge, I think in paragraph 9, but you can look at that, highlights the importance and the role of the judiciary when it comes to national security by reason of Article 3.3 to actually exercise and consider the question of bail, bearing in mind the need also to prevent, suppress, and not just punish national security crimes. So therefore, in Article 43, one is also looking at that as a basis upon which we have actually gone about drafting it. And I think there are the one that Martin has mentioned, which is new, that is the taking down of certain posts that are on the web. But generally, we very much follow what is generally familiar with the people, with the practice in Hong Kong with that stuff.
Thank you, Teresa. We have quite a number of questions. I thought a very excellent question has come from, I don't think Bernardo Mendia would mind my quoting his name. And if I could just clear up a little bit, because I thought that is an excellent question. And Bernardo is the president of the Portugal Hong Kong Chamber of Commerce. And he says this excellent down-to-earth explanation from Judge Litton. I wish the impartial, unbiased international media could have access and time to listen. As president of the Portugal Hong Kong Chamber of Commerce and Industry, which has as its main interest the promotion of business between the two regions, I would like to ask the panel on how we can promote more effectively the true narrative about the contemporary history of Hong Kong in particular Hong Kong's NSL. What more can we do? That's an excellent question.
Can I start?
Absolutely.
I think what you have just done, Tony, through the Asian Academy of International Law is an excellent thing. I think we need to reach out to people and explain and answer questions. We cannot give specific legal advice. We cannot deal with a specific case because they all turn on facts. But I think speaking more and reaching out to people in exactly these sort of events, I think would be something that would be extremely useful. And of course, for Bernardo, for example, to perhaps to help share the points that you have picked up to your colleagues and your members, and if need be, I'm sure these sort of events can be organized again.
Indeed, if I could say to Bernardo that the AIL would be very pleased to organize anything with you if you could contact us. Now we have a number of other questions. One technical question. Perhaps I'll deal with that. I'll ask that technical question of Professor Chan, in fact, and that question comes from a barrister in Hong Kong. And the question is this: while you said that the national security law is not superior to the HKBL, that's the basic law, however, Article 17 of the basic law empowers the National People's Congress to invalidate any inconsistent laws. If the National People's Congress can invalidate local laws, then is it correct to understand that Hong Kong LegCo is therefore subject to NPCSC's invalidating power? A technical question. Would Professor Chan like to deal with that?
Hi. Can you hear me?
Yes, we can hear you.
All right. Yes. The local legislature of Hong Kong is subject to the People's Congress Standing Committee's power, but to a certain extent only. Because the reviewing power or the power to return the local law of the Standing Committee is confined to the articles concerning the relationship between the central government and Hong Kong. So that power, I understand, should be limited. But that's my answer.
Thank you very much indeed. I think there's also a little bit of jurisprudence on that in the case that we have in the High Court on the masking case as well. So you might want to read that, Mr. Barrister. Now, a number of other questions. Perhaps one simple question is that somebody asked whether the PPT of the webinar will be available. Let me tell you that they will be available, definitely available after this session. We will actually have a recording of this session put onto our website, including the PPTs. So now we have a question from the Chinese. 请问国安法实施中会不会寻求人大解释?
The question is in Chinese. Will the implementations of NSL requires the interpretations of the central government?
So will we meet a time when the interpretation of the National People's Congress will be needed? Of course, in the national security law, there is a reservation to interpretation of that law by the National People's Congress. When would that take place? Difficult to tell, of course, at this stage. But I would think, and I would ask my panelists, I would think myself that before that happens, we will actually have cases in the courts, and the courts in Hong Kong will be, in fact, the first interpreters of that law, because they will have to apply that law in the context of a case, in a prosecution perhaps, or in case where, in fact, a search power is invoked, and the question is what are the limits of those powers and so on. So those will be cases that the Hong Kong courts will deal with, and it's only when these cases cannot deal with the question in particular then perhaps we might use that. But what do you think, Secretary?
Well, I think you've answered it all. Bearing in mind, of course, Article 65 of the National Security Law specifically and clearly states that. We know that would be the final statutory interpretation that would be provided by the NPC. The procedures, of course, is very much I would expect, and of course we have Professor Chen who will let me know whether I'm correct. Will very much be something along the lines of what is similar to like in Article 158 of the Basic Law. So I think those are the power that is there, and we would expect first of all the courts to be dealing with it generally.
Thank you. Well, we have a very interesting question, and we'll ask this. The speakers have explained why the national security law accords with the principles of one country, two systems. May you address how the law as it stands also appropriately reflects the tenets of Xi Jinping's thought? Let me say this. Let me just say this. That the Xi Jinping thought is always, of course, within, in fact, the party manifesto of the 18th and the 19th Parties Congress. And you can rest assured that if National People's Congress passes the law, it definitely reflects the tenets of Xi Jinping thought. The other thing I would suggest that the person who asked this question might look at, in fact, the website of the Hong Kong and Macau Affairs Office. In fact, they do actually have a great deal of information on how national policy is translated, in fact, into their work. So it's very easy. Just Google that, HKMAO, and you will actually get that. And I think we've done basically most of the questions, if not all of the questions, that we could answer as part of this this forum. Well, before I leave the session and do a few concluding remarks, I'd like to ask any of our panelists if they would like to say anything. Well, I'll ask the Secretary first.
Well, I just heard that through this sort of medium, we're able to convey the correct message about what the national security law is so that people fully understand it. And bearing in mind it is dealing with endangering national security, the normal business and commercial activities in Hong Kong, the normal daily lives of people in Hong Kong will not be affected. So I wish very much to convey that correct message.
And Professor Chan, any parting words that you would like to say to our audience?
I think there are two perspectives. The first is the realistic perspective. You know, Xi is the chairman, the president, and he's also a chairperson of the National Security Committee. So the making of a national security law, I think, should be reported to him, I mean, in the decision-making process. And so practically, I think this law, of course, incorporates his ideas. And ideologically, if we want to find out what tenets of Xi's thought is reflected in this law, we need to find out what is common between Xi and the former presidents on the 1 country, 2 systems, and what is different, what is spatial ideas. I think there is one simple way to find the difference. Of course, much of the ideas are the same, but I think there is a very simple way to find the difference. And that is a practical way, that the making of this law is very different from what the former presidents have done. I think so. The theoretical way should go back to the practical way. And we could see in what ways the national security law has implemented the basic principles of the basic law. That's my answer.
Thank you very much. Henry, any parting words you'd like to say to our audience?
Yes. Whenever a problem arises, you can look at it in two ways. In the short term or the long term. Now, by long term, when we're dealing with issues like the national security law, the long term would be, for example, what would things look like in the year 2049 when the nation will be celebrating the 100th anniversary of the founding of the PRC? And if one took the long-term view of things, I think the perspective would be very different. Because for the youth of Hong Kong, those who have been demonstrating in the streets and so on, I mean, the year 2049, they would barely reach middle age. Now, what would their future look like at that time? And if the focus is on the long-term perspective, they may have a very different attitude to what we actually see displayed in the streets today. But even for the older people, people even of my age, but surely we have, what is our purpose on earth if not that of custodianship and stewardship to nurture what we have and pass on to the next generation? So the message I would like to convey is, let's look at things with long-term perspective in mind and not the short term.
Thank you very much. And Martin, any parting words?
Only to start with the same words that Henry started with, which is when there are problems, people should talk about them, people should communicate. The more communication there is on this topic, as I said, commendable that the government is participating very actively in that communication. The more communication, the better.
Thank you. Well, I think we've come to an end of a very, I think, hopefully, a very formative evening, and certainly one which certainly inspires me personally. We see that national security law represents, in fact, a milestone, in fact, in the journey of one country, two systems, and it is a long journey. As Henry quite rightly puts it, one has to look at the long term on this, and we have to see our role in society. And I cannot agree with Henry that we are all stewards and custodians. The national security law, in fact, does two things, I think. One, of course, as Professor Chen quite rightly puts it, it establishes our constitutional identity. We are all part of one nation. But at the same time, there's a tremendous respect given to the idea of one country, two systems, in allowing prosecutions, in fact, to be started by an independent authority in Hong Kong, by the prosecuting authority without fear or favor, according to the facts and the law, a judiciary which independently adjudicates the case, again in accordance with the law. And in the end, of course, whether one country and two systems succeeds is how we, the judiciary, the community as a whole, how we calibrate, as Henry quite rightly puts it, in fact, our own values as well as the values and the constitutional identity of our system. So one thing that I would like to remind all of you is that we have not talked about sanctions tonight. And next Tuesday, in fact, on the 29th, the AIL will have another webinar on sanctions, in fact. So before we conclude, I would like to invite my friend Lumai to give us concluding remarks. Lumai.
Thank you, Tony. I've heard that the translation interpreter speak wonderful English, so I prefer to speak English. 我想讲三点。第一点，今天晚上的讨论。
I want to talk about 3 points. I would like to commend the organization of today's event.
对我来讲是一个很好的学习。我们以前只是从整体上来看国安法，今天晚上听到了这么多第多少条啊，这是法律界才能有的，我们学习很多。看来有2个方面，一个方面呢是说国安法，可能有人还存在着一些误解，本身他已经说清楚，比如说无罪推定啊等等，啊，这个今天晚上做了很清楚的解释。第二个，因为它是一个大的法律，那么在具体的实施中，还会根据很多的具体情况，那么来进行啊，所以还是有一个实践的过程。在这个过程中，各方面可以把它更进一步细化，更进一步完善。跟香港国安法密切相关的一个问题，就是它的出台是为了解决香港前一段出现的问题，那么就是社会失序啊，这个各方面在所谓抗议啊造成的混乱。我90年代中期曾经在香港生活，对香港各阶层这个人民也都是有所接触。去年我又回到香港，那么看到的一些情况是有变化。香港呢，从这方面讲可能是进步，就是说年轻人，尤其是年轻人和知识分子更加讲求自由，讲求民主，讲求自己的权利。我想这是社会进步，也是很难避免的一个过程。但是呢，必须画出红线。这各种对自己权利的追求，一定不能够以伤害别人的生计为代价，比如占领中环，比如说占领湾仔码头等等，一定不能够破坏整个社会的经济发展为代价，啊，这是不能容许的，所以才有这个国安法。我能够理解，就是我们经过文化革命，年轻人、中学生是极容易被鼓动起来的。那么现在我们在香港又看到了这种情况。我希望年轻人在讲求自己的权利，在追求进步的同时，还是要懂得对社会上所承担的责任。第二个，我特别赞赏列显文法官所说的，大法官所说的，我们要望眼2049。其实呢，回顾过去，1840年，那么在鸦片战争中啊，这个清王朝失败了，然后香港被割让。那么经过这么多年，香港1997年终于回归。唐德刚教授是一位历史学家，他曾经说过，就是从1840年开始啊，中国要经过一个历史的三峡，然后实现民族的复兴，这个过程大约需要200年，这是他的一个预测。邓小平先生曾经预测，在80年代的时候，他就指出，中国要在本世纪中叶要实现现代化。那么刚才这个列显文大法官又提到了啊，就是中华人民共和国建国100年，就是习近平主席所提的2个100年啊这样的奋斗目标，这是历史的潮流。中国在这个大的潮流里边，14亿人显示了自己的勤劳、勇敢、好学啊、智慧，所以才能够有现在的发展。这个潮流恐怕是谁也挡不住的啊！ 这个国运所在，历史的潮流所在，要选择站在这一边。即使在这个过程中可能会有一些不如意，可能会有一些就是做的不够好的地方，但是大的潮流是在这里啊。这是我希望，尤其是香港的年轻人应该看得清楚这一点。香港曾经在四小龙中是很突出的，现在在四小龙中处于什么位置？香港曾经是中国大陆就是内地的所有的城市需要效仿的，现在处于什么位置啊？所以那些法官所说的话是值得我们考虑的。第三个就是我说中央政府对香港没有什么特别的要求啊，因为97年回归以后，当时港澳办是受中央政府当然领导要求，就是严格控制政府的官员到香港访问。所以有人曾经说，那么香港回归以后，到香港反而更难了啊，比出国还难。它的目的就是一条，不要干预香港，真正的践行一国两制。这一点到现在也是没有变化的。实施一国两制啊，港人治港，高度自治，这点是没有变化啊。但是香港在目前的国际形势下，不要成为大国博弈的棋子，这是毫无意义的。这个对于香港来讲，对于香港人民来讲是没有好处的。所以应该在这个大势中吧，也要看到，中国在这个和平发展、在崛起的过程中，那么现在面临的国际环境有变化，而香港现在正是处在这样一个漩涡之中。我希望大家能够这个携手同心啊，展望未来。像列显伦先生说的，我们大家共同努力。我最后想要说，就是中国发展研究基金会非常荣幸，能和这个梁景邦先生啊和他的组织一起来主办这个会。过2天就是国庆节，就是中秋节了。我们衷心祝愿大家这个国庆节、中秋节啊2节快乐。中国人民讲究团团圆圆的传统，我们但愿人长长久，千里共婵娟。所以我想借此表达对香港的衷心祝福，祝福在祖国实现民族复兴的伟大征途中，香港的明天更美好。谢谢。
Thank you very, very much, my friend.
To prosperity.
If I may finally then thank Lu Mai, my friend, and the CDRF, and all the speakers tonight, as well as all of you viewing our webinar. And I look forward to seeing some of you, if not all of you, next Tuesday on our WTO webinar when we deal with sanctions. And good night. And thank you, everybody.